abandoned her own child. She is mentally and emotionally unfit to be a mother, Your Honor. The court should place full custody with me immediately." My ex-husband didn't even flinch when he said it. He stood at that podium in his pressed navy suit, the one he always wore to make himself look trustworthy, and he lied. Smoothly, calmly, like he'd been rehearsing it in his bathroom mirror for months. Which, knowing him, he probably had. I didn't move. I didn't gasp. I didn't reach across the table and flip anything over, even though every nerve in my body was screaming. I looked at the clock on the wall instead. 11:47. We had been in this courtroom for 6 minutes. Have you ever sat completely still while someone you once loved dismantles your character in front of a judge? Drop a yes in the comments if you know what it costs you to stay quiet when every instinct says, fight back. I want to know how many of us have had to swallow that. His name is Marcus. We were married for 4 years. We have a daughter together, Cora, who is 6 years old and currently staying with my mother in Raleigh because I did not want her anywhere near this building today. Marcus had requested an emergency custody modification. His filing claimed I was unstable, erratic, financially irresponsible, and emotionally unavailable. It claimed our daughter was in danger in my care. It requested that he be granted primary physical custody, sole legal decision-making authority, and that my visitation be supervised. Supervised. Like I was a stranger. Like I hadn't been the one who stayed up 3 nights in a row when Cora had the flu in February. Like I hadn't learned how to braid hair on YouTube because her hair is curly like mine. And I didn't want her to feel like her hair was a problem to be solved. The family law attorney beside me, a quiet woman named Patricia, had told me before we walked in, do not react. Whatever he says, do not react. You will want to. You will feel like you have to defend yourself in real time. Don't. She was right. I knew she was right. I had spent 3 months preparing myself for this exact moment. But sitting there, listening to Marcus describe me as someone who abandons her child, I had to remind myself of the most important thing I knew going into this room. He didn't know what I had. He thought this was a custody hearing. He thought he was winning. He had no idea what was in the folder on the table in front of me. The judge, the Honorable Catherine Okafor, looked up from her notes. She had sharp, careful eyes, the kind that didn't miss much. "Mr. Marcus," she said, "you've made some very serious allegations regarding the fitness of the child's mother. You're alleging emotional instability, abandonment, and financial mismanagement. Before we proceed, I want to hear from her directly. Ms. Odom." She looked at me. The room went quiet. Marcus leaned back slightly in his chair, relaxed. Victorious. His attorney, a man I'll call Philip because that is in fact his name, shuffled papers with the energy of someone who thought the hard part was already done. I had seen Philip before, not in court, in the parking garage of the building where Marcus worked downtown 3 months ago, getting into the same car as Marcus at 8:45 on a Tuesday morning, 2 men in expensive suits, laughing at something on a phone. I had taken a picture without really knowing why. Turns out, knowing why comes later. I stood up slowly. I smoothed the front of my blazer. I did not look at Marcus. "Thank you, Your Honor," I said. My voice was even. "I'd like to respond in full. But first, I want to make sure the court has the complete picture, not just the version my ex-husband rehearsed." Philip's pen stopped moving. I sat back down. Let him go first. Let him build the whole house of cards. That's when you pull the one at the bottom. Marcus took that as his cue to continue. He pulled out a printed document and slid it toward Philip, who passed it to the bailiff. "Your Honor," Marcus said, his voice warming into something performatively sad. "I have bank records showing that over the past 18 months, my daughter's college fund, a 529 account established jointly at the time of our divorce, has been drawn down significantly. Nearly $40,000 has been removed." I watched the judge's face as she reviewed the document. The gallery shifted. Behind us, in the back rows, sat Marcus's mother, his older sister, and 2 of his cousins. I had noticed them when I walked in. He had brought an audience, just like I expected, just like they always do. They want witnesses to the moment you crumble. I heard his mother whisper something, probably something about how she always knew. People like her always knew, conveniently after the fact. Marcus wasn't finished. She has been living beyond her means. A new car she can't afford. A lease in a neighborhood she has no business being in. She took our daughter out of her private school and enrolled her in public school without consulting me, claiming it was a better fit, when the truth is she simply ran out of money. He paused for effect. Your Honor, my daughter deserves stability, and her mother is not providing it. He sat down. The room felt heavy. I could feel the weight of his family's judgment pressing against my back like a hand. Here is what Marcus saw when he looked at my life in the past year and a half. A woman who left a $90,000 a year marketing director job to freelance. A woman who moved out of the house they'd shared and into a smaller apartment 20 minutes away. A woman who drives a used Subaru she paid cash for, who shops at Aldi, who enrolled her daughter in the public school 2 blocks from their apartment, because it had a 9.4 rating on Great Schools, and an arts program Cora had been begging to join for 2 years. He saw someone failing quietly. He did not see the LLC I registered in Delaware 14 months ago. He did not see the SaaS contracts I had been quietly building on the side for the past 2 years while working my corporate job, 3 mid-market companies that paid monthly, retainers for marketing infrastructure I had built from scratch. He did not see that I had left my job not because I was falling apart, but because my freelance income had crossed $180,000 in the trailing 12 months, and I no longer needed the salary. He did not see that the drawn-down 529 account had been moved, not spent. I had rolled it into a custodial brokerage account in Cora's name after doing the math on long-term growth projections. The money wasn't gone. It was in a different pocket, one that had grown by 11% since the transfer. He did not see any of that, because I had not shown him. I had a reason for that. Ms. Odom, Judge Okafor said, setting down Marcus's documents, these are significant claims. The financial records your ex-husband submitted do appear to show a depletion of the jointly established account. Do you have an explanation for that? The room held its breath. Marcus uncrossed and recrossed his legs, confident. I reached for the folder. I don't have an explanation, Your Honor, I said clearly. I have documentation. I walked to the bench and placed the folder in front of her. I took my time. I was not in a hurry. People who know the ending of the story are never in a hurry. Tab 1, I said, is the account transfer confirmation from Fidelity. The $40,000 was not spent. It was rolled into a UGMA custodial account, also in my daughter's name, also for her exclusive future use. The account balance as of last Friday is $44,612. The 529 was underperforming. I moved the funds to a position that has returned 11% in 14 months. I paused. Let that land. Tab 2 is the current account statement. Judge Okafor flipped to it. Something in her expression shifted. Marcus leaned over and whispered urgently to Philip. Philip's jaw had gone slightly tight. Tab 3, I continued, returning to my seat, is my business financials for the past fiscal year. My LLC generated $183,000 in gross revenue. My take-home after expenses and taxes was just under $120,000. I left my corporate job voluntarily, not because I was in financial distress, but because I had built something more stable. Silence. His mother had stopped whispering. The apartment I lease costs less per month than our old mortgage. The car I drive, I own outright. The school my daughter attends has a 9.4 community rating, a nationally recognized arts curriculum, and a student-to-teacher ratio of 16:1. I switched her because it is the better school, not the cheaper one. Marcus was very still. He had built his entire case around the idea that I was failing, that I was broke, that I was too scattered and too unstable to parent our daughter without his oversight. He had not done his research. He had made an assumption, the most dangerous kind, the kind based on what something looks like from the outside when you've already decided what you want to see. I watched him recalibrate. It was not a flattering process. His face cycled through confusion, then anger, then the very specific kind of embarrassment that only comes when you realize you have humiliated yourself in front of a judge. But Marcus was not a man who accepted defeat gracefully. I had been married to him. I knew this. He reached into his briefcase. "Your Honor," he said, his voice steady again, recovering fast, the way he always did. "I have an additional document I'd like to submit." He nodded to Philip. Philip stood, crossed the room, and handed something to the bailiff, who passed it to the judge. "This is a co-parenting agreement," Marcus said, "signed by my ex-wife 14 months ago. In it, she agreed to notify me of any significant financial decisions regarding our daughter's accounts. Moving $40,000 without telling me is a direct violation of that agreement. Whatever she's done with the money, she made that move unilaterally, in secret, without my knowledge, which is precisely the kind of erratic unilateral behavior that I'm asking this court to consider." I felt the room shift again. My cousins, the ones I had invited as quiet moral support, sat straighter in the back. I could feel the tension coming off Patricia beside me. Judge Okafor looked at the document. Then she looked at me. "Ms. Odom, is this your signature on the co-parenting financial agreement?" I looked at it from across the room. I already knew what it said. I had been waiting for this. "Yes, Your Honor, that's my signature." Marcus let out a breath, a small, controlled exhale of relief. Philip made a note on his legal pad. "And you acknowledge that you did not notify Mr. Marcus before transferring the funds?" I acknowledged that I did not notify him in advance, yes. Marcus turned to look at me. It was a look I recognized, the look that said, "I've got you." I let him have that for exactly one breath. "However," I said, and I heard Philip's pen pause, "I'd ask Your Honor to turn to tab 4 of my documentation." I waited. Judge Okafor turned to tab 4. It was a certified letter, dated 14 months ago, 1 week after I made the transfer, sent to Marcus's home address via USPS certified mail, return receipt requested. In it, I had notified him in writing of the account transfer, the rationale, the destination account information, the growth projection, and Cora's new account number. Below the letter was the green card, the return receipt, signed by Marcus himself, confirming delivery. He knew. He had known for over a year. He had signed for the letter with his own hand and said nothing because the money was safe, the account was growing, and there was nothing to complain about. Until he needed something to complain about. "He signed for this letter 13 months ago, Your Honor," I said, my voice calm and final. "He has been aware of the transfer since the week it occurred. He did not raise a concern at the time. He is raising it now because it is useful to him now, not because my daughter was ever at risk." The silence in the courtroom was a different kind of silence than the kind at the beginning. That silence had been heavy with judgment aimed at me. This silence was aimed at him. Marcus looked like a man who had just realized the door he thought he was walking through was a wall. His mother sat very still in the back row. Philip was writing something, quickly, the way lawyers write when they are trying to figure out how to salvage the next 20 minutes. But Marcus had one more move. I knew he did. I had spent 3 months studying him, the same way you study a chess opponent. Not just the pieces they move, but the ones they reach for when they're losing. There was one more thing he was going to try. He reached into his briefcase again. He pulled out a slim manila folder and held it for a moment before passing it to Philip. "Your Honor," Philip said, standing slowly, "we also have testimony from a licensed therapist who has been seeing the minor child. This therapist has documented concerns about the child's emotional presentation during sessions, including statements the child has made about feeling anxious at her mother's home. We would like to submit this as supporting evidence that the current living arrangement is not in the child's best interest." The room moved again. My aunt, sitting 2 rows behind me, made a quiet sound. I kept my face still. This was the move I had anticipated. This was the one that had kept me up on 3 separate nights trying to figure out how to handle it without doing damage to my daughter in the process. Because this one involved Cora's actual words, or at least a particular framing of them. Here is what I knew about that therapist. Her name is Dr. Petra Walcott. She had been seeing Cora for 8 months, initially at my suggestion, because Cora had been having some adjustment anxiety after the move to the new apartment, and I wanted her to have a professional space to process it. I found Dr. Walcott through our pediatrician. I paid for the first 6 sessions out of pocket. Somewhere around month 3, Marcus had started attending the check-in calls. I'd assumed that was fine. Co-parenting. Involvement. I had not yet realized that he had begun calling Dr. Walcott directly, outside of those calls. I found that out from the phone records I had pulled, not surreptitiously, but from my own account, because he had called her twice from my phone during a weekend. Cora spent with him when he borrowed my charger, and apparently my phone. Those calls lasted 22 minutes and 14 minutes respectively. I had also reached out to Dr. Walcott myself 3 weeks before this hearing to ask a simple question. Had she been contacted by Marcus's legal team about submitting documentation for a custody case? She had not. She told me directly she had not agreed to submit any documentation. She had not written any formal report for this proceeding. I had asked her to put that in writing. She had. It was in tab 5. Your Honor, I said, before Philip could build any further momentum, I would ask the court to please turn to tab 5. Judge Okafor turned. Tab 5 was a signed statement from Dr. Petra Walcott, dated 3 weeks prior, confirming that she had not submitted any formal clinical documentation to either party's legal team for the purpose of this custody hearing. The statement also noted that any informal communication that may have occurred between Dr. Walcott and either party outside of scheduled sessions was not intended to constitute clinical testimony and should not be represented as such. At the bottom, in clear language, Dr. Walcott had written, "It would not be appropriate or ethical for me to characterize a child's therapeutic statements as evidence of parental unfitness without a formal evaluation and court order. I have not conducted such an evaluation and have not been court-ordered to do so." Whatever Philip had in that manila folder, it was not what he had implied it was. It was, at best, informal notes. At worst, something Marcus had asked for, that Dr. Walcott had not agreed to provide in the form he presented it. Philip sat back down without submitting the folder. Judge Okafor set down my documentation. She removed her glasses and held them in both hands, a gesture I had noticed she made when she was about to say something definitive. She looked at Marcus for a long moment. "Mr. Marcus," she said, "you filed an emergency motion claiming your daughter was in imminent danger in her mother's care. I have now reviewed documentation showing that the financial concerns you raised were known to you for over a year. I have reviewed a statement from your daughter's therapist clarifying that she has not provided formal clinical documentation to this proceeding. And I have reviewed financial records indicating that the child's mother has been operating a successful business, maintaining a stable home, and making financial decisions that are, by any reasonable measure, in the child's interest." She paused. Emergency motions are a serious tool. They carry weight because they imply urgency, genuine urgency, the kind that exists when a child is actually at risk. Filing one without that urgency wastes this court's time and causes unnecessary harm to the other parent, and more importantly, to the child. Marcus's expression had gone very flat. "I am denying your motion for emergency custody modification in its entirety," Judge Okafor said. "The current custody arrangement will remain in place. I am also ordering that within 30 days, both parties participate in a parenting coordinator session to establish clearer financial communication protocols going forward." She looked at both of us. "Not because I believe Miss Odom has been unclear in her communication, but because I want these conversations to happen on record and in structured settings so we don't end up back here." She closed the file. "Ms. Odom," she said, "your documentation was thorough, and your conduct in this proceeding has been measured. The court appreciates that." I nodded. "Thank you, Your Honor." "We're adjourned." The gavel came down. And that was it, the whole thing, start to finish. 91 minutes. Marcus's family filed out of the rows behind us quietly. His mother did not look at me. His sister did not look at me. They had come to watch something fall apart, and instead they had watched a man dismantle his own credibility in front of a judge using a letter he had signed himself a year ago and forgotten about. Outside, in the hallway, Marcus stopped me. "I want to tell you he said something gracious. I want to tell you he acknowledged what he'd done. I want to tell you that somewhere in there was the person I had once believed I was building a life with. He didn't. He looked at me with the kind of cold contempt that told me he had already decided this was my fault somehow, that I had tricked him, that I had been too prepared, too organized, too ready, and that this was, in some logic, available only to him, something I had done to him, rather than something he had done to him, rather than something he had done to himself. "You think you're so smart," he said. I looked at him for a moment. I thought about 4 years of marriage. I thought about the night Cora was born and how he had cried, genuinely cried, and I had thought that meant something permanent about who he was. I thought about the night I found the texts he forgot to delete, the way I had sat on the bathroom floor for an hour before I stood up and decided I was not going to be defined by what someone else chose to do with my trust. I thought about the 3 months I spent building tab 1 through tab 5, while he spent those same 3 months building a case out of assumptions he never bothered to verify. "I'm not trying to be smart," I said. "I'm trying to be Cora's mom. That's the whole job." I walked out into the afternoon. It was warm. Raleigh in late spring has this particular kind of warmth that feels generous, like the city is offering you something. And that afternoon, it felt like the first day of something rather than the last day of something else. I called my mother from the parking lot. "Tell Cora I'm coming," I said. "Tell her we're going to that Brazilian place she's been asking about." "How did it go?" my mother asked. "It went fine," I said. "He brought everything he had, and it wasn't enough." She was quiet for a second. "Did you leave anything for him?" I laughed, actually laughed. "I left him his pride," I said. "He'll tell himself a story about this. He always does." I got in the car. I drove out of the parking garage and into the warm May afternoon, and I did not look in the rearview mirror once. Here is what I know, after all of it: the preparation, the silence, the nights I spent doubting myself, and the mornings I spent deciding not to. The thing no one tells you about protecting yourself and your child from someone who has decided to use the system against you is that it is slow, exhausting, invisible work. No one sees the certified letter you mail in October. No one sees the spreadsheet you build at 11 at night while your daughter is asleep. No one sees the moment you choose not to respond to the text designed to provoke you because you know it will be screenshotted and reframed. They only see the outcome. But you feel all of it, every single step. So if you are in it right now, if you are in the middle of something that feels like it will never resolve, if someone is trying to build a story about you using the silence you've had the dignity to maintain, I want you to hear this. Document everything, date everything, send things certified, and when the day comes, let your paper trail do the talking. Silence isn't weakness. Sometimes it's the longest, most patient sentence you've ever written. I keep coming back to the certified letter, the green card, the one he signed with his own hand in October and then pretended didn't exist when it became convenient to pretend. That detail still gets me, not because it was clever on my part, but because of what it reveals about how people like Marcus operate. He wasn't lying out of desperation. He was lying out of habit. He had done it so many times inside our marriage and outside of it that he genuinely expected it to keep working. He expected me to show up to that courtroom the same way I had shown up to too many arguments in our kitchen, unprepared, reactive, defending myself in real time against accusations I hadn't seen coming. He didn't account for the version of me that had spent 3 months building tabs 1 through 5, while he spent those same months building a case out of assumptions. That's the thing I want to sit with for a second, because I think it matters beyond just my situation. What Marcus did was a kind of theft, not of money, not technically, but of narrative. He tried to take my story and replace it with his version, the version where I was failing, scattered, unfit. And he tried to do it in a room with a judge and a gavel where stories carry legal weight. That's not just dishonest. That's a specific kind of wrong that takes real calculation, real willingness to use a child as leverage, real comfort with causing harm when it serves you. The outcome he got, sitting in that courtroom watching his own certified signature get passed to the judge, was not a coincidence. It was the direct result of the choices he made, all of them, across months and years. Actions move in one direction and land somewhere. They always do. But here's what I had to learn. And it did not come easily. Surviving that required more than knowing I was right. Being right and being able to prove it are completely different things. I had to think clearly when everything in me wanted to react emotionally. I had to understand financial instruments well enough to make a documented argument for why I moved Cora's money. I had to read a co-parenting agreement carefully enough to know that a certified letter would satisfy its notification clause. I had to anticipate a therapist being weaponized and act 3 weeks in advance to neutralize it. None of that was instinct. All of it was work, quiet, unglamorous, invisible work that no one in that courtroom saw until it was already done. And then there was the hardest part, the sitting still, the not reacting when he called me a bad mother in front of a judge and his whole family. That took something I don't have a clean word for. Some combination of discipline and grief and absolute refusal to hand him the satisfaction. I had to decide over and over again across those 91 minutes that my daughter's future mattered more than my need to defend myself in the moment. That's not easy. I don't want to make it sound easy. There were seconds in that room that felt like they lasted an hour. But I held. And because I held, the folder did the talking. I think about Cora sometimes, about what I want her to understand when she's old enough to understand any of this. I want her to know that her mother didn't win because she was lucky, or because the system worked the way it's supposed to, or because some external force intervened on her behalf. I want her to know that preparation is a form of love, that integrity, actual integrity, not the performed kind, is the thing that holds up under pressure when everything else falls apart, and that the capacity to stay quiet when you're afraid, to keep building when no one is watching, to trust the process even when it costs you sleep and peace and certainty. That capacity is something you grow. It doesn't arrive. You build it the same way you build anything, one decision at a time in the dark when no one's looking. That green card, that small rectangle of paper with his signature on it, he signed it. He just didn't think I'd keep it.